Good evening, everyone. My name is Dolores Dorsonville, and I'm the co-chair of the Education Committee for the Maryland State Bar Young Lawyers Division. And we are pleased to have you here tonight for our first CLE seminar for the bar year, entitled Hot Tips and Hot Topics for Young Lawyers. I'm joined by my co-chair, Taryn Stanton, in the front row. And our committee is committed to offering educational programming and professional development seminars for young lawyers throughout the state. Tonight we have an excellent panel of attorneys from different practice areas who are going to talk to you tonight about the different areas that we've outlined: negotiation techniques, technology, mobile apps, as well as ethics. But before we begin, I want to take a moment to thank our co-sponsors for tonight's event. As you know, through the generous support of our co-sponsors, we are able to put on this programming and provide refreshments, of course, at no cost to you. So I want to start by thanking Merrill Ladd. They are Denny in the back, Denny Rudolph. Merrill Ladd is videotaping tonight's program for us. So for those of you, or for those attorneys that you know of who are not able to make it here tonight, we are going to provide a webcast of this on our website. So you can view it later on. Additionally, we have with us tonight the managing partner of the firm Tribe, Butler, Mayo, and Griffith, Anthony Butler, who's another co-sponsor. Thank you very much, Mr. Butler. And lastly, we have our sponsor, Sims Chiropractic, and we have Nicole Williams here on behalf of Sims Chiropractic. And we're going to give our co-sponsors an opportunity to say a few words, starting with Nicole.
Good evening, everyone. My name is Naquandra.
We're gonna work it.
It's fine. It's fine. But that's better than what I used to get. But I am the practice representative from Sims Chiropractic Center. I'm here today because our motto is "We have your back." So we want you guys to have our back by sending personal injury people to our firm. And we're out here today doing free spinal screenings because I know it's very stressful being a lawyer. So basically my screenings measure the pressure off your spine that you get, and some people have already been screened, so definitely come out and see us. And we have cards, and we would love to take your cards because networking is the key. Thank you.
Thank you. And I'm sorry about that. Now we're going to hear from Denny Rudolph from Merrill Ladd. Thank you.
Being around all these lawyers gets me stressed out. Well, listen, I want to thank you all for having us here again. Thank you. You always ask us, and we love doing it. I know a lot of you here, and some I haven't. I see you all got our pads. Thank you very much. We also have, this is kind of cool, we have calendars for the year 2013. They actually come apart and they get attached to your computer wherever you can, take them off and take them home or take them to your office. Real quick, I was talking to a couple of attorneys here about one of our services. Excuse me, we have 6 conference centers. A lot of you come from some large firms, but smaller to mid-sized firms. You're solo. We have 6 conference centers. They're in Annapolis, Greenbelt, Baltimore, Washington, Tysons Corner, and Rockville. We have these brochures back there that explains it all to you. It shows the outside of the buildings, all the accoutrements that are in all the conference centers. They're free for you to use. All you have to do is call and say you're with the MSBA. I'd like to use a conference room, say next Monday from 1 to 2 in DC or Baltimore, wherever. We will let you come in to meet your client, do whatever. You don't have to pay anything. We would like you, if you have to depose somebody, we'd like you to use us, of course. That's just part of it, but it's not mandatory. So, but we just want you to get to know us, get to see what we are, and get to come into our space. So please don't hesitate to call. Thanks.
Thank you.
Thank you.
That's excellent. I'm hoping many of you will take advantage of Denny's offer. We've been using Merrill Ladd for several years now for our video conferencing, and I can attest that they do excellent work. Next, I want to make sure that everyone has the written materials for tonight's discussion. We have a number of handouts on the front table, so if you walk past and didn't get a chance to grab them, make sure you grab them. And we're also going to put them up on our website as well. So if you know any other attorneys who were not able to attend, make sure you share that information with them. I'm now going to introduce our moderator for this evening, a man by the name of Huey Hunt, who happens to be a good friend of mine and a colleague. Huey Hunt is a graduate of George Washington University Law School. He is also the founding partner of Kemet and Hunt, a firm in Prince George's County, Maryland, where he heads the firm's civil litigation group. His practice area includes probate, contract, real estate, divorce, and family law matters. In 2006 to 2007, Huey was selected as the chair of the Young Lawyers section of the Maryland State Bar Association, becoming the first African American in the history of the Maryland State Bar Association to hold this position. He has served on the executive committee and board of governors for the MSBA. During 2007 and 2008, Mr. Hunt served as the American Bar Association's Young Lawyers Division District Representative for the District of Columbia and Delaware. He remains an active leader in the legal community. So without further ado, please join me in welcoming our moderator, Mr. Huey Hunt.
Thank you, Dolores. That was pretty nice of you. This is long. All right. First thing, we only have a few people. How many first-time attendees here tonight? All right. Your homework is we got more chairs than people, and we got a camera. So if you could move up a little bit into the first 2 and 3 rows, that would make a better environment. Because I'm sleepy, I know you're sleepy, and we're going to get through this. We're going to make this worth your while. And if you don't feel like you got anything out of it, you can get your money back from Dolores. I'm going to take a little time before we get started to introduce our panelists here today. To my immediate left is Mr. Kevin Finnegan. He's the founding member of Goldberg, Finnegan, and Mester, LLC. His practice consists of representing clients who are seriously injured victims of medical negligence, truck and automobile collisions, wrongful death, defective products, and other catastrophic personal injury matters. He's licensed to practice law in Maryland, both in the state and federal courts, as well as in D.C. He's tried hundreds of cases and has argued cases before the Maryland Court of Special Appeals. And to my second left is Tiffany Relaford. She's an associate at the law firm of Whiteford, Taylor, and Preston. Her practice includes labor and employment litigation, advice, community associations, litigations, and business litigation, where she represents multiple insurers in the areas of law, including personal injury and professional liability. And to my far left is Mr. Butler. Anthony is an experienced trial attorney and diversity inclusion consultant. His experience includes significant work in several industry sectors, including financial services, sports and entertainment, manufacturing, and consumer products, where he has served organizations of all sizes in both legal and human resources. And I guess do I need to introduce you, Dolores? Dolores is bar counsel, and that's all you need to know about her. You don't want to talk to her. You don't ever want to meet her. You don't ever want to get a letter from her. If she ever calls you, hang up and run away. No, sorry, Dolores, I had to. Dolores is a senior staff attorney with the D.C. Office of Bar Counsel, where she investigates and, where necessary, prosecutes allegations of ethical misconduct of District of Columbia lawyers. She's formerly an assistant bar counsel with the Attorney Grievance Commission of Maryland, where she prosecuted disciplinary matters against Maryland lawyers. Dolores is also an adjunct professor at the American University Washington College of Law, where she teaches legal ethics to second-year law students. Just kidding about that. If she calls you, you should answer. So we're here today, and I don't know, solo practitioners, small firm, show of hands. We're here today to just talk about some of the hot tips, and I always say when we do these things, you should leave here with an idea of how to make more money, because it doesn't make any sense to come to these things if you can't convert it into something, right? So I'm going to give you some of my experiences doing my presentation. They're going to give you some experiences and hopefully give you some ideas on how to improve your practice to make more money. Now, we're going to have a free-flowing conversation here today. That doesn't mean you just stop someone when they're talking. But if you have a question, raise your hand. We're going to get to you. I think the question and answer method keeps everybody awake and it keeps it lively. So I don't know which panelist wants to go first. Anyone?
Sure. I'll go first.
All right.
I'll go first. Okay, so Kevin and I, we're really going to talk about our negotiation tips and tactics. Can you all hear me? I'm not very good with microphones. And we developed what we call our 6 negotiation tips, and these are just kind of key points that we thought would be good for young lawyers to know when preparing for negotiations, mediations, conciliations, things of that nature. And one of the most important tips that I recommend is to always prepare and know the facts of your case. That's always important because you need to know, one, what are the strengths of your case? What are the highlights of your case? What are the things that are important to convey? In the converse, you also need to know the weaknesses of your case. Some of the weaknesses that you think may be weaknesses may not be weaknesses once you get into a mediation or negotiation. But it's important to know those because you need to know what your leverage is for certain aspects in a negotiation. It's also important to know the case posture. I know when I practice in the District of Columbia, oftentimes you will file motions for summary judgment, things of that nature, dispositive motions, and the cases are set for mediation before those motions are ruled on. So that's something important to know when I'm in a negotiation. Is this the end all of this case? How strong is the outcome of my motion for summary judgment or my dispositive motion? Do I know that it's more than likely that's going to be granted if we're unable to come to some sort of resolution in mediation? So it's important to know, what is the posture of your case? Where are you in the case? Is this an early mediation? Are we here to see if maybe there's a way to resolve the case, but really we're gathering facts to help us later on when we get further into litigation? It's important to keep that in mind. Another tip in just preparing and knowing the facts of your case is to know your strategy. Everybody has a different strategy. Some people go in and they're just nose hard bulldogs. They know this is what we want, we're not leaving with anything less. Others, like myself, I'm more of informational. So I will go in, I will let the person know what they need to know about the strengths of my case, but I'm more there to listen. I'm going to hear what the other counsel has. What are the strengths of their case? What are the weaknesses of their case? Because that's important for me to know in evaluating what I want to put on the table or what I don't want to put on the table. It's also important to know who you're dealing with on the other side of the table. And that affects your strategy, whether you're dealing with a particularly aggressive counsel on the other side or somebody that's more laid back, easygoing, and it's a more collegial atmosphere when you're negotiating.
I think what we're going to do is just maybe...
Can I jump in and ask a question? Does that change, for instance, in different practice areas? Would a mediation for a personal injury matter be quite different than a wrongful death, or are you still kind of using the same methods for each one? Can someone speak to that?
I think it's case specific, and I think when it comes to presenting your strengths of your case at a negotiation, and I'm going to use probably a mediation setting as an example because I don't know how many people do plaintiff's personal injury work, but when you're dealing with an adjuster on the phone, it's really like talking to a robot. And
it's a large waste of time.
Yeah, I mean, there's only
For
so
anyone
far
who's done it.
there's only so far you're going to get. But if you're in a mediation, it's a lot different because you have the adjuster there in person. And in a mediation setting, I like to talk to the decision maker. So if I'm in a mediation, and the mediator wants a little spiel from both sides before you start, I talk to the mediator, but then I also talk right to the adjuster. I don't even talk to the attorney. They know the case, I know the case, and no matter what I say to the attorney, nothing's going to change in there. But I like to talk to the decision maker, who's the adjuster. And I'll talk to them about facts.
Could we explain to the audience what you're saying? Because some of them may have never had a personal injury case. You say there's an adjuster at the mediation. Why wouldn't an adjuster be present?
Okay. On any personal injury matter, if there's an insurance company on the other side, that company is going to defend and indemnify the defendant, obviously. So there's an adjuster assigned to the file to control, one, the defense of the case and what money is spent on the defense of the case, but two, what money is going to be offered to resolve the case if the case can be resolved. So
and don't feel bad, I didn't know that when I started practicing law either. And no, you don't sue the insurance company, you sue the individual.
In some cases, you sue the insurance company, but you're right, 99% of them, it's the individual. So in a mediation setting, the adjuster will be present if there's going to be any real chance of resolving the case. And you don't know what's been shared with that person by the attorney. If the attorney sent them, for example, the deposition of both parties in the case, you don't know what facts that attorney's really given them. So I like to highlight my strengths directly to that person, that adjuster, and tell them, look, this is what the case is about, and present all the strengths of the case. And include in there things that they may not know about because it wasn't part of the discovery. So if there are witnesses you know of in the case that weren't deposed by the defense lawyer, and you know you're going to be calling those folks at trial, and they're going to be helpful to your case because of certain facts that they're going to testify about, that's when I like to those are things I like to present at the mediation and tell the adjuster exactly what these people are going to testify to. So I'm not sure if I answered your question, but
Very good, John.
as far as how to deal with weaknesses, as Tiffany said, you need to identify your weaknesses before you negotiate the case. I like.
Can I give you a hypothetical weakness?
Sure.
I mean, it's a personal injury case and your client blew a .07. But the other person kind of ran a red light. That would be a weakness.
That could potentially be a weakness.
How would you handle that?
Well,
I hate to put you on the spot, but
that
you've
could
tried
be.
over 100 cases. It's probably easy for you.
That potentially could be a weakness if it's admissible, and I guess you first need to sort that out, whether or not it's going to be admissible at the trial. And if it's not, you can tell the adjuster in the mediation why it's not going to be admissible in the event that hasn't been discussed with them. But assuming it is going to be admissible, I don't know what you can do with that other than to just talk about your strengths and hope that they don't focus on that.
That's what I was gonna say.
Yeah.
Do you discount the case a little bit? I mean, when we talk about weaknesses in the mediation, what does that really mean? Are you saying if you have a case where it's a very strong case with no weaknesses, you go on with a particular view of, okay, I'm taking 3 times the amount of damages, or I have a set amount of money I'm seeking, and I'm not really going to back down off that position. And conversely, if you have a weakness, do you say, all right, I have this weakness, so maybe I have a little bit more room to, come off of my position?
I think if it's a weakness in your case and the jury's going to hear about it, yeah, I think it's going to discount your position in the case. Sure, absolutely. But if you think it's something that a jury's likely to disregard, and you can convince an adjuster that in a mediation, I'd try to. But when dealing with the weaknesses of your case generally, and I like to do this also when planning for trial, because I think you have to address your weaknesses in your opening statement. I think you need to really sit down and think about what the defense, what their plans are going to be in defending the case, and then in your opening try to spoil their plans. Address your weaknesses in your opening and explain to the jury why you don't believe they're going to be relevant in the case. And I think you need to do that in a mediation too. If you have a case where the person had a prior injury, the exact same body part they hurt in the accident you're representing them for, the insurance company may be discounting in their evaluation, maybe discounting your case for that because they've been able to find out either through gathering medical records or doing a search through old claims that your clients made. And they found out that they had a prior injury to say their knee. Well, you need to deal with that obviously in any negotiation, and hopefully you will have prepared to deal with that, and you can say something to the adjuster like, well, I know certainly they've injured this body part before, they've injured their knee before, but we've gone out and got 5 years of medical records from their primary care doctor's office, and in the 5 years leading up to our accident, they never had any complaints of that old injury ever. And we have a coworker, we have a supervisor, we have a family member all going to come in at trial and say that old knee injury wasn't relevant anymore. They recovered, they were back playing basketball or back golfing, do whatever they did before, and so that's really not going anywhere. With respect to the case posture, Tiffany's right. I think you need to consider when the negotiation should begin. In the personal injury field, for example, there are generally 3 or 4 different times when a negotiation is going to start, and it's usually after your client is done with all their medical care. If the case doesn't get resolved then, it's right after you file a lawsuit and the insurance company actually has to get the defense of the case started with an attorney, or after they've taken your client's deposition and they've met your client and evaluated how they're going to do as a witness. And so certainly the case posture plays into when a negotiation is going to start. Okay.
Sure. Question in the front row.
Actually, something I'm dealing with now, maybe some other younger attorneys may understand this. What are your thoughts about dealing with the difficult opposing counsel? I mean, particularly ones that bully or like to threaten, maybe not you in particular, but maybe your client, or just use very strong language on the phone. And this is more like, this is particularly thinking about my situation where it's trying to settle the case just, out of the courtroom, and I think particularly maybe younger attorneys probably get this from more senior attorneys. They know, oh, this is a younger attorney. I'm going to try and maybe bully them during the settlement negotiations. How do you think that people should deal with that? And in particular, what are your thoughts on, using tactics such as this one guy said, I'm going to put your client out of business, or I'm going to do an IRS tax audit and you guys are going down. Those type of things. How do you?
That's scary for me.
No, I mean, and maybe some of you may use these tactics, plaintiff's attorneys, but
Don't be mentioning the IRS right now.
what are your thoughts on that for younger attorneys who are dealing with sometimes other attorneys that are bullying, maybe saying things that just are not the most professional? How would you guys?
Well,
deal
can
with
I
that?
just jump in? It is an ethical violation for an attorney to threaten, opposing counsel to get an advantage during a litigation. So, I mean, there is an actual.
I mean, is that true?
Yeah.
He didn't know he
can't
didn't threaten
legally
my
threaten
life.
them?
Well, he
I'm
didn't.
going to file a
I will
complaint
say
if
this.
you don't give me money.
He did threaten one of the attorneys in the case. He said, I know that so-and-so has some skeletons in the closet, so he better watch it.
Ooh.
And I said,
Don't we all?
Are you throwing down on my client, but another attorney? Oh, okay, that's nice. So anyway, I thought that might be interesting, and I don't know if other people may have dealt with that, or particularly people who are younger and solos may come upon people who aren't so on the up and up.
I mean, I think one of the first things is being direct with people and being assertive. Just the fact that you're younger than someone more senior than you doesn't mean that you are in any less of a position than they are. You can be assertive, you know your case better than anybody else, so you need to make sure that you convey that. I have had difficult counsel. I'm normally on the defendant side. So I've had plaintiffs counsel that because they didn't like a settlement offer that was made, they will call and they will yell at me.
Oh, yeah.
And I will admit that I have hung up on the phone on people. But what I've said to opposing counsel is, I'm not going to talk to you if you're going to treat me this way. You can call me when you're ready to have a civilized conversation. I've hung up. And I remember one case, this one attorney, twice that has happened, and I followed it up in an email. And I said, pursuant to what I just told you on the phone, I will talk to you when you're ready to have a conversation, but I won't deal with you berating me or whatever over the phone. The attorney called me a day later, apologized. And we were able to come to a resolution. So a lot of it, I mean, when you have situations like that, don't think that you have to tolerate it because you are younger or you're in that position. I think you need to be assertive. You need to tell the person they're crossing the line, and then you can end the conversation there. If you're in a negotiation, you can take a caucus. You can ask for a break. You can leave the negotiation. You can go talk with your client for a while. You can come back in. And other times, a lot of times when you have people that, especially attorneys that may be distrustful on the other side and they use those sorts of threatening tactics repeatedly, follow up things by email. Document those conversations so that it's very clear where you stand and what your position is.
I found that normally, and going back to Tiffany's first point, if you know the facts and the strength of your case, rest on that. Again, don't be bullied. Take steps to protect your reputation and your image and your style. But if you know the facts of your case, they can bully and posture all they want to.
Right.
If you know the facts and you know the strengths of your case, and you keep going back to the strengths of your case, which it ultimately comes down to. And if you can project that on the phone, in person, or no matter what venue you're in, ultimately that is what will prevail anyway.
Yeah, and I think it's also important not to engage people when they
Yes.
take the conversation to a place it's not supposed to go. Sometimes silence is just golden.
Yes.
People don't know how to respond to it. And, talking to adjusters is almost a complete waste of time. Like, usually, unless somebody's like a paraplegic, they're not offering you anything that you're going to take anyway. So, and I'm sure Brother Counsel can speak to that. So sometimes having a conversation is a waste of time anyway. So it gets to the point when you have to use your own kind of judgment in these situations. I mean, who are you as a lawyer? But I don't think anyone should ever let someone berate them or, speak to them in a way that's uncivilized. I just don't, think you should allow that to happen. Anybody else have any points on that?
Just real quick, just to repeat something that Tiffany said, always follow up those conversations in writing. And then I always give the person one more chance. I've dealt with it before also. I always give the person one more chance and say something in that first letter or email. If this happens again, then we'll be at a point in the case where all future communication will have to be in writing. And I've had that happen where no more phone calls. Everything had to be either fax or
Yeah, I don't
email.
like I
Or letter.
try and avoid
Yeah.
phone calls.
I have that as well.
Well, Dolores would tell you the time to take a phone call is when you want to avoid it. That's in the client area.
Bickering.
Go ahead.
No, I'm not on the panel, but I've had to deal with that a lot too as a newer practitioner, and it actually has been helpful because what happens, especially in negotiation, is their client starts looking at their own lawyer like, my lawyer's such a jerk. And I start looking like the voice of reason in the room. So the client's like, shut up. Yes, we'll go with that deal. But I guess the question behind that, though, is I often have started to wonder now, in trying to be the gentleman in the room, is it possible for a client to come back later and say, you didn't fight hard enough? Or say that, you weren't zealous enough, and then all of a sudden...
I can feel that for you, brother. It doesn't matter whether you're a gorilla or you're a passive. I mean, there's always the possibility your client will have kind of buyer's remorse the day after the settlement. It happens all the time. I settled a case, and I settled it at 10 a.m., and at 2 p.m. my client called me and said, can we change it? I mean, it's been on the books for 4 hours. I haven't even typed it yet, right? So that happens to all of us to some degree, but you can prevent that by kind of, papering the file, writing letters, explaining it properly. But ultimately, these decisions in settlement are always the clients. They're never the lawyers. It's always their decision. And to the extent they feel like you forced them into a position and then they don't like it, that's just bad news for you. So you have to remember that.
Right, and one thing, especially for the newer practitioners, you will get the client, whether it be a criminal client, and if you're in plea negotiations, or if it's a personal injury client and you write a settlement, they'll always ask you, well, what would you do? Do not answer that question. I always put it back on the client and say, I have my opinion about what I would do, but it's just that my opinion. It's not my life. It's not my facts we're dealing with. It's you and your family situation. So you need to do what's best for you and your family. Leave it there. Do not let them, don't let your client bully you either into that corner, because then that's when they will come back. Well, attorney so-and-so said that's what he would do and it was the best thing for me. And that's when you're going to, get those phone calls from certain offices you don't want to receive.
The dreaded blue letter.
One thing I was going to say, and I'd like you guys to maybe comment, is along those lines is they say, what should I do when you're trying to explain, well, if we go this way, this may happen. If we go that way, this might happen, and trying to explain it to them on the phone. Would you guys agree that that's another opportunity to then send a letter or an email just to cover yourself? Because a lot of times, you're telling them on the phone,
And they're not listening.
and unless they're very, they're general counsel and a sophisticated client, would you guys agree that it's always good during those type of discussions to also follow it up with a letter or email, just to make sure that, these are your options, and you tell me which one you want to pursue.
Yes.
Yeah, more communication is always better than less, but sometimes the physical reality of it all, if you're a small firm practitioner, you could literally spend hours just writing letters to clients that aren't producing any revenue. So it's a kind of a constant, push and pull for those of you who don't have a secretary or administrative assistant. So, but to the extent you can communicate more, always do more.
And That's actually a great segue into our second tip, which was managing your client's expectations. And it goes to that. And making sure that you understand what is the result your client is seeking, especially if you're in a mediation, arbitration, negotiation. Now, I'm normally on the defendant's side, and I normally have adjusters. I've been retained by an insurance company, whether it's an employment discrimination case, personal injury case, something of that nature. So I have, with adjusters, normally when you work with them, they ask for what are called status reports. And they ask for reports on what are the strengths and weaknesses of the case, what is an outcome that we can expect from this case, what is the likelihood of a verdict being entered against us, what is the amount of a verdict. So normally I will have gone through that process with an adjuster or my client. But that's definitely a conversation you should have with your client, because the worst thing that can happen is you go into a mediation, your client has a completely unrealistic expectation that maybe they're going to get $50,000 for a case that's really valued at $5,000, and you're at a table trying to negotiate, and you can't get your client to move away from that number that they have ingrained in their mind is what the value of the case is. So that's very important to do, and to follow up, I would follow up in writing if you're able to do so.
Yeah, I do as well. Whenever I'm presenting a settlement offer to a client, I'll make a quick note. Right as soon as I get off the phone with a client, I'll make a quick note in the case management system we have. Or if you don't have a case management system, just, and just type a memo really quick in Word or something like that. Just talk to Mr. or Mrs. Smith. We talked about the strengths and weaknesses of the case, the offer, and the settlement offer is X. Just to document that you presented the offer to them, and you talked about how to deal with the offer, whether it's a counter offer or they need to think about it, make a decision, whatever. And right after I settle a case, this morning had to drive to Salisbury today to meet with a client. On the way there, I settled the case, and as soon as as I was driving, I will admit, I emailed my secretary as I was driving. Just spoke with Mrs. So and So. She agreed to settle her case at X amount of dollars. Please put it. Start getting the settlement papers ready, just so it's documented. So if she comes back like the next day, like you said, or later that day and says, I didn't agree to settle the case, or I wasn't sure that, the case is the case resolved now, or isn't it? I can at least show, if you ever go down that road further, like they try to back out of it, that, it was settled in my mind, and I, sent an email to my secretary saying it was settled, so.
I wonder if it's a little different in family law.
Oh my God.
Because you might come into the settlement conference and you've spoken to your client and you understand the case, but then, for instance, the custody evaluator comes in with the report and gives a report which you didn't have access to before. You're in there, and you might be blown away by what they have to say. And then
in Prince George's County, usually the custody evaluation is, okay, judge, you make the decision. Usually. But in those situations, the whole family law arena is totally different than any other practice area. First of all, it's never over. It's just never over. You mediate on Tuesday, you settle it, you go to court on Thursday to put on the record the whole world has changed the night during the pendency of the agreement and the court case. So it's an emotionally charged situation. There's years of history between the parties that you have no idea, no grasp on. So that whole arena is a different context of mediation. I always like to say it has to be a little heated in family law. People have to get their emotions out. It's an important part of the process because it's something that is very important to each individual. It's not just money. So you get in these mediation sessions in family law situations and you find even the lawyers are arguing. I mean, everybody's arguing. So sometimes you take it up and you take it down. It's a complex thing. And it's not something that many lawyers I know enjoy mediating family law cases because they can be so emotional, and you can be faced with a report that you get 5 minutes before the trial that totally goes against what your client was saying. All right, the best interest attorney may totally go against what your client is saying. So those type of things are just it's hard to know exactly what's going to happen in a family law case. The only thing you should know is how much money you're being paid. You should know that, because him telling you the number one areas of complaint are, go ahead, Dolores, tell us, what areas?
There are several.
Which is number one?
Fee disputes tend to be at the core of a lot of disciplinary complaints.
And what practice areas?
Well, family law is up there, but additionally, so is criminal immigration, bankruptcy.
And personal injury.
Personal.
And usually it becomes what we're talking about, client expectations, which I believe are important in every practice area, especially in personal injury. Because you get somebody who has broke their finger and they want $10 million. You got to kind of like bring it in a little bit, and that's a skill. And then in family law context, the same thing. People come in wanting a certain set of things, and sometimes it's just not realistic. But we all are continuing to learn how to do that. Any questions? Let's move on.
I want to talk for a second about client expectations, and it can be especially challenging when it comes to personal injury matters. And what I try to focus the client on is that we first need to, and I always try to have these conversations in person when it comes to evaluating their lawsuit. And I try to explain to them it's not the value of what you went through, it's the value of your lawsuit. And the lawsuit is going to be determined based on the evidence in the case. And we have evidence that is very helpful, but guess what? The other side has evidence that's not going to be so helpful to you. And so I try to focus that conversation on the value of the lawsuit, not the value of what they went through, because that's when they have expectations that are just unrealistic, because they did have some significant injury to their person, and it threw a big monkey wrench in their life for a period of time, but you need to get them beyond that because it can create some unrealistic expectations. And then you have the clients who will just tell you from the get-go, I want a trial, I want a trial, I want a trial, I want a trial. And if you have a client like that, you've got to be ready to try their case, one. But two, I think you need to change that conversation to what does it really mean to have a trial, and talk to them about what it really means. And tell them what, one, how the trial is going to work, what the evidence is going to be. I mean, sit down with them and go through their file, go through the evidence that the other side has, whether it's a defense medical exam, whether it's things in their own medical records that are hurtful, because most clients, especially in a personal injury case, you get their medical records and you start having this conversation with them, they're like, wait a second, I never told the doctor that. Oh my God, he didn't put in the records that I told him my knee hurt on this visit. And, I never told my doctor this, and I never told him that. And then they start to see the challenges of their case because their medical chart says one thing, even though they remember something else. So it's good to sit down with them, go through what the evidence in the case is, and explain to them this is what is going to happen at trial. And when you have a defense medical exam, sometimes you get a defense doctor who isn't so nice to deal with, but sometimes I think you're fortunate when you have a doctor who's actually a good doctor and personable. One, because you're more likely to get an honest report, but two, because you can ask your client, what did you think of Dr. So-and-so? And if he's an honest doctor and he's a good personable doctor, they're going to say, you know what, I really like that doctor. He treated me well. He seemed like he knew what he was talking about. And then you get to say to the client, well, that's what the jury is going to think. That's what you thought after 10 minutes. That jury is going to be listening to the defense doctor for an hour. And that's what they're going to think. So you need to understand that. When you go to trial, you're going to have another doctor on the other side who's going to be presenting a different kind of case. And he's going to be saying, you were hurt, but you weren't hurt that bad, or some of these problems pre-existed. And if the jury believes that doctor who you liked, you're going to have a problem. If you can't get through the client for whatever reason, either they just don't accept your evaluation, or they still say, I want a trial, I want my day in court, you can try to get a third party involved, like a mediator, and explain to the client that you
But
think...
shouldn't you just try the case? I mean, a lot of times I found as lawyers, we get out of what we're trained to do. Sometimes you just got to try it.
I agree. Sometimes you just need to try it.
Sometimes you got to try it. It's what you do.
But if it's a case where you're trying to save the client from themselves, which often happens,
is most of them.
you may be successful in talking the client into having a mediation in the case, and then you go out and get a retired judge as the mediator. Hopefully get the other side to agree to it, and you go get a retired judge, and that person can talk to them about what trials are really like, because they've sat on the bench. And if that doesn't work, then you're trying the case.
Nobody can argue with those results. I guess the Court of Appeals exists for those things. Did you have anything else, Counsel?
We're on section 2. I don't think I have anything else there. Okay. Moving on to section 3, assess the value of settlement. What is the benefit of settling? What is the cost to all parties? Will settlement discussions be ongoing? How do you overcome obstacles to settlement? There's kind of some overlap here with what we already talked about, but when assessing the benefit of settling a case, again, when you have that conversation with your client about whether to settle or not, or try the case, I think you also need to talk to them about what the cost of the case will be if it does go to trial. Because in some cases, they're not that significant, but in some cases, they are very significant. When you got to call in a liability expert or 2 or 3 doctors in the damages part of your case. So I think that needs to also be laid out for the client. And if you get a client who's difficult and has a bad case and is going to put you in a position where they're going to make you try their case, and you know that chances of success aren't very good, you may want to talk to the client about advancing the cost in their case. I mean,
That sounds like a bar counsel like diagram of the worst possible way a lawyer can get involved with a client.
let's talk about that, because I think there's a correct way to do it and a wrong way to do it. If in your retainer agreement, you indicate there that the client, which I think you have to, and this is the way that we do it, that the client is responsible for the cost of their case, but your firm may advance the cost at their discretion.
May advance. That's very important.
I got to tell you that we advance the cost in all of our cases, unless we're in a position like this where you have an unreasonable client and they're going to make you try a bad case, and you're trying to avoid that. And sometimes you just can't because of the timing of when this all happens. You just have to try the case. But sometimes if it's early enough, I think you can have that conversation with the client and follow up with a letter and say, look, our retainer says we will advance the cost at our discretion. This is not a case that we believe we can be successful in winning for the following reasons. And therefore, I understand that you don't agree with our opinion, but we are in a position now where we need to ask you to advance the cost of the trial in your case, and it will be X. Please.
So what happens when they don't advance it and the trial is approaching? What do you do?
Well, I think if they tell you early enough that they're not going to advance the cost, they don't have the money, or they're just unwilling to do it, and it's at a posture of the case that, let's say you're still in discovery, you're not even close to a pretrial, you don't even have a trial date. Well, then I think you need to determine whether or not you're going to withdraw from the case. And if it's early enough that you can withdraw from the case safely and not do any harm to their case, meaning it's early, there's no trial date or anything like that, there's time for you to do it, and I think you can do it. And I'll be interested to hear Dolores' take on this.
And not in the District of Columbia.
And then you file your motion, you follow the rules, and you see what a judge does. But I think that's a way you got to cover yourself if you have to go down that road.
And if you withdraw properly, if you do this, follow the steps, you give the client notice in the appropriate amount of time, and then after that amount of time, I normally wait an extra week before I actually petition the court to give them time to respond in case mail is lost. I have never been denied a withdrawal if you do it properly. Paper the file.
I've done it properly and I've been denied.
I'm not you.
Thank you. No, but I think it just depends on the jurisdiction.
Yeah, but it does.
And it also depends on the judge.
Yeah.
There's no hard and fast rule on how courts will let you out. I've had courts let me out 25 days before trial. I've had courts make me stay in 2 years before trial. We haven't even filed we had a scheduling order yet. So I think it really just depends on the facts and circumstances of the case, and also the judge who's hearing the case.
True. True.
Talking about negotiating, I guess you guys have your own strategies, so I don't want you to tell me everything, what you guys do, but, for someone who's younger and particularly people who are solo and trying to settle a case on their first time, I guess a couple questions. You know, someone, let's say, offers, I don't know, they offer 10,000 and you were at 5,000. What do you guys see as far as
7,500.
You know, like, how do you, that's the thing, like, how do you, as someone who's a younger attorney and trying to figure out what to come back with counters, you know, what are your thoughts? Do you guys think, you know, in every case, you guys kind of have a strategy of just go up every 500, every 1,000. What are your thoughts on that? And then another question, strategy-wise, if you're doing this via email, having these back and forth, do you guys believe in the idea that, you know, don't respond right away? Like, you know, if they send it at 2 o'clock, don't counter at 2:30. Wait till the next morning. So, you know.
Are we talking about dating, or are we talking about? What are we talking about?
And maybe these are, but these are for people who are newer at this. I mean, you want to try and put I think, and that's why I want you guys to speak on this. I think part of negotiating and settling isn't just about the actual case, but how much of it do you guys think it's about strategy and timing and oh, well, if he says 7,500, you know, I'm going to come back for my 5 to just 5,500, or, you know, those type of things. How much do you think those things should play into, you know, trying to settle a case, or do you think those things are just in bad taste?
Sure. I think some of it is strategy, but it also depends on the case. For me and for what I do, for example, if I have a case where I'm collecting on delinquent assessments, I already know what number I'm going at. So I'm not going to go with I go up 1,000, you come down 1,000. I'm going to tell you it's X number, and that's it, because there's not a lot of room for negotiation in that.
I guess you're CarMax. Yeah. Just give me one price.
That's it. There's not a lot of room for negotiation there. Maybe an employment discrimination case where maybe you are sitting in some sort of a conciliation where we're trying to go back and forth and find an amount. I am still, personally, I'm not a fan of I come up 1,000, you come down 1,000, because I think it can be a waste of time, especially if you were so far apart and we spend 2 hours doing this and we're never going to come anywhere near the range where everybody wants to be. I'm not a fan of that tactic. But I think starting out, you need to know, okay, what is going to be too lowball of an offer that you're going to offend the other party versus what is going to be an offer that's high enough that will get their interest and will get them to come to the table and negotiate in good faith. So that's what you really have to think about. I wouldn't get too caught up on the increments of the 50 versus 500 versus 1,000. You just really have to keep in mind, what can we put out there that's going to elicit a response that we're going to be able to work from? I think that's really the key.
Yeah, you need to determine, before you even start a negotiation, you need to determine the value of your case. Mm-hmm. And whether you do that just based on your own experience, or if it's a case that's unusual, and you need to get other.
Can you talk a little bit about that? Because I mean, we always talk about how do we value a case, but let's say I come into your office and I got $20,000 in meds. Liability is determined. How much is my case going to be worth? It's a car accident case. I mean, how do you?
Soft tissue.
Soft tissue, car accident case, $40,000 policy. I got $25,000 in meds. What do you say?
Well, it's obviously
it's a softball. It's a softball.
It's obviously case specific, but if you're telling me you have a 40 policy and you have 25 in meds, I say it's worth 40.
Exactly. That's the point I'm saying. It's a fluid thing. I mean, I may be able to get 75, but right. The client is not going to be the defendant is not going to be able to pay it. They're going to pay 40. That's what the insurance pays. Mm-hmm. So these concepts, it's not necessarily how much your case is worth. It's how much you're gonna really get, you know, and that's really what you have to assess, because you can go get $1 million judgment and spend 10 years trying to collect on it, or you can take the freaking 40 grand and go home now. I mean, it really is. It really just depends on the case, and you only know these things when you file suit, because the insurance companies aren't going to tell you what their limits are until you file suit and you get some discovery. So a lot of times I found in smaller cases, just file suit and ask for 30 grand like the rest of us. Get some discovery, and then you see what the policy is, you know, and then you work from there. Then you have to determine what you're likely to get. But getting a judgment in a district court couldn't be simpler. If you're in a district court practice, it just couldn't be simpler.
Yeah, in a district court case, I mean, the way we evaluate cases is you look at the specials, and in our opinion, most district court judges on a good day will give you $2,000 a month of pain and suffering, unless it's an unusual case. I'm just talking about straightforward rear end case, soft tissue, whatever. Most judges on a good day will give you somewhere in the range of $2,000 a month for pain and suffering. So if they treat it for 2 months, it's $4,000 pain and suffering. You add that to the specials, that's what you're going to get on a good day. And then you see what the company's offering, and if they're close, then you talk to your client about, look, if we try the case, maybe you get another $500, but if you get a bad judge instead of a good judge, you may get less. So, but if you have a case that's bigger than that, not a district court case, and you're having a hard time determining what the value is, in the office we sit down, get a handful of us, 3 or 4 lawyers, and we present the case, and then get everyone's opinion. What do you think the case is worth? Now, if you're a solo and you don't have other lawyers in the office to do that, call somebody up who that does personal injury stuff, and ask them what they think the value is. This way you can at least document the file and say, this is what I think about the case, and I talked to so-and-so, and this is what they think. So at least you have some basis to give recommendations to your client. And then when you deal with your client, I always tell them, look, this is what I think the value of the case is. And this is what I think the settlement range is. And if they come into the settlement range, I would recommend that you take it. Now, if they're above the settlement range, great, we did great. If they're below, then you're going to have to make the decision.
Right.
And if they're way below, I'm going to tell you, look, that's an offer that's just, like there are black and white offers and there are gray offers. If it's a black and white offer, you're not taking it. I mean, I'm going to tell you it's up to you, but I wouldn't recommend you take it because it's so low that it's just not fair. Or if it's in that gray area, that's going to be a decision you have to make, and I'm going to tell you, I can't tell you what to do. It's your decision. It's in that gray area, and it's close to what you could get, and it's within the range.
I was also going to say, if you don't know what the value of your case is, like Kevin had said, in addition to talking to other people, research jury verdicts. Research verdicts with facts similar to yours to see how the court has made a determination on those cases, what the rulings have been, because that can also be insightful and good information to have.
Now, how do you research jury verdicts?
Oh. Well, in Maryland, D.C., and Virginia, all of them have their own databases. You can go through Westlaw, you can go through Lexis, and some of the individual bar associations do report the jury verdicts, and you can put in just by simple facts, dog bite case,
Right.
and see what the verdicts have been in those types of cases. I've done this in wrongful death cases where there have been drownings for maybe young children to see where the court has typically gone with verdicts in that area based on those facts. But it's good information to have, and it's especially helpful. This is a little bit off subject, but if you're looking for experts in a case, medical experts, different types of experts, you can look in these cases and it'll tell you who the experts were for the defense, who the experts were for the plaintiff. And that's another way that you can find expert witnesses if you need them in a case.
Yeah.
Sir?
I heard someone say earlier that sometimes you will put in a letter for your client if you don't think it's a good case. This is what I think it'll cost you. And I've kind of been nervous about doing that because, of course, opposing counsel, they can turn it to World War III if they want to. So maybe bar ethics wise as well. I mean, are you held to that number? What kind of wiggle room do you have there? Because like I said, I just try to stay away from it altogether.
Well, I think he was speaking to more of what it would cost for, if you have a doctor or some type of expert to come. Right. There's a general range they give you, like, okay, Huey, it's going to be $5,000 a day. You got to fly me in, and I got to stay at the Westin, right? So that's going to cost X amount of dollars, and that's really what they say. If you have an expert, these doctors are crazy. I'm sorry. But as far as the litigation costs, you're right. You don't know. I mean, you got 10 depositions. You want to depose the whole world. You got to discover. You don't know how much the case could cost. So you should never bind yourself. Never do a flat fee ever. Never say, look, this trial is going to cost you $500,
Right.
Unless you're just willing to accept that it could drag on and on and on. But once you bind yourself, as Dolores will say, you're bound.
It's perfectly acceptable, of course, to give your client an estimate of what you believe the cost or the expenses will be. And that will, of course, be based on your experience with similar type cases. But, if for some reason, the case has extraordinary facts or something happens that was unforeseen, I mean, that's not necessarily a bar council issue, but it's always safe and of course practical, I think, to give that information to your client going in so that they have a good idea as to what it is that they hope to net at the end of negotiations.
And I would also say, if you know how much you have spent to date, and you know what the settlement offer is that's coming in, that is information you can give to your client. I've spent $10,000 to date already on this case, and we aren't even through discovery, and we haven't gotten to depositions or anything else. They're offering you a settlement of X, Y, and Z. That gives somebody a realistic gauge of, okay, well, if I take this settlement, then I may be out $3,000 versus if we continue going forward, it's going to cost more, and who knows what the next settlement offer may be.
I remember when I thought $10,000 was a lot of money. Go ahead. Any other questions?
Yeah.
Could it also be that too, if you do a flat fee, or like if you do pro bono, and so they're like, oh, keep fighting it forever, you have more and more motions.
Yeah. When they don't pay, they want to fight until you die. Exactly. Because there's nothing hurting. That's why people settle, because it costs too much money. But when you don't charge them, they will call you every day. It's just, that's how it is. And if you bind yourself to it, you got to live up to it.
And that's why I always tell my clients, principles are expensive. Because you'll get the client all the time like, I want you to take this contingency or pro bono because I think it's a just case and it's the right thing to do and it's just the principle of the matter. And I learned a long time ago to tell all of those people that principles are expensive. And because they don't have, if it's a contingency fee case and they don't normally see what we're spending to help litigate their case, they have no idea whatsoever. Most people when they come to you for these personal injury cases, family law cases, even criminal cases, have little to no experience with any type of court system litigation whatsoever. So we often have to explain to them what that means. And I think because we talk to each other all the time, we think everybody else knows what we know. Or we think that everybody else knows at least 5 lawyers. They don't. They don't. So they have no clue. They have no basis of comparison whatsoever. So we have to educate as while we represent them as well. Because if we don't do, and especially with pro bono, I take MBLS cases all the time, and you've got to tell them this is what it costs. And I even for those clients, if it gets too much, I send them a sample invoice. Like every time you call me, that's 1/10 of an hour. So if you were paying, this is what it would have cost you. And normally after that kind of conversation, they go, oh, I didn't realize that this is all the work you do and this is what it takes. And they normally retreat and so it's part of educating them as well to know that this is what it is. Because you have those same clients that email you at 2 o'clock in the morning. They call the office, then your cell phone if they have it, at 2:30 in the morning because you didn't answer the phone call at 2 o'clock in the morning. So you've got to, right.
That is the lawyer's worst nightmare.
It is.
A pro bono client that files a bar complaint. Gosh dang it.
That actually goes to client selection as well.
Right,
part
exactly.
of what Anthony discussed. Because what I find is that that's one of the red flags, a client that can't be satisfied. Essentially, if you're taking on a matter, through our tribunal system, it means that essentially it will end up, litigation, and that's the only way to make them whole. But if a client tells you, it's not about the money, it's about the principle, run.
Principles are expensive. My response is principles are expensive.
My favorites are also the clients that come in and ask you what your success rate is.
Right.
Those are ones that I stay away from.
You just have to say you're successful every time you're successful.
Yeah, follow up, go ahead.
And with the pro bono cases though, if you're getting referred one of those cases, often you don't know what you're getting until you've gotten it.
Right. But as I've still, well, at least my experience in BLS, and I'm to the point now that I only take pro bono through a agency. I do not take walk-in, cousins referral, previous clients referral. The only pro bono cases I do are through something like that, and primarily in BLS.
We're going to try to keep it moving a little bit, but just by show of hands, who has had a personal injury mediation or some type of negotiation? Okay, and then family law and any other type of mediation. Okay, so most people in the room have been in some form or some set of mediation. Did you have anybody, did the panelists have any closing remarks they wanted to make on that?
My only closing remarks are just making sure that when you're in the mediation and conciliation, take good notes. Make sure that because some of those notes you gather facts that you never knew, especially if you don't come to a resolution. Those are facts that you can use hopefully later on. Also, stay focused on the issues. Don't let the mediation get derailed into things that are not important to the case, because that becomes a waste of everybody's time and your clients start to lose focus as to why they're really there. Keep an open mind, and also recognize that when you've reached an impasse in a conciliation, a mediation, or arbitration, there's nothing wrong with that, but you need to recognize that we're not going to come to any sort of agreement, so we all just need to walk away. And maybe you can continue negotiations over the phone or at some other point in time, but know when you've reached an impasse.
My comments on a mediation, I guess, are, I'll just add, cover yourself. With 90% of your clients, you're never going to have a problem with it, but it's that 10% or 5% that's going to make your life miserable. In every mediation I go to, I put down what the offer is, what the counter demand is, and I have the client initial right next to it. Offer, counter offer, until the case is resolved or we just stop. And I do that in every mediation. I started doing it years ago. And believe me, I've had to use it from time to time when a client comes back and tries to mischaracterize what was happening or what was offered or what the case was settled for. And about reaching an impasse, in my philosophy, if I'm at a mediation and I'm there to negotiate a case, I'm there to settle the case. But if you can't get it settled, don't forget about trying to, as a last measure, of last resort, maybe trying to work out parameters for an arbitration. And maybe the case can get resolved that way. If you don't want to, if for some reason you think the case is not suitable for trial in front of a jury, you can explore possibly arbitrating the case in front of a lawyer or retired judge, and at the mediation try to work out the parameters of that arbitration. So at least you're able to accomplish something.
Butler, did you want to make any closing remarks on that?
Nope.
Really?
I'm good. Hey, I stay in my lane.
All right, we're gonna keep it going on, and I believe Mr. Butler, you're gonna be talking about technology.
That is correct. By show of hands again, how many people are in solo practice or small practice group, just starting out? And this, so I've got one of the handouts you got today. I've gotten this evening is a presentation I developed a while ago with Pat Yevix. If you don't know who Pat Yevix is, you need to. Solo and small firm section of Maryland State Bar Association is a great resource for you. So this is one I developed a long time ago, and I kind of tweaked it along the way. Actually, Huey and I will share some of this responsibility. I'm going to talk about hardware, software, and I forgot my third topic. Hardware. Your initial assessment, hardware and software, and then probably the newer age. Huey's going to add some comments about some of the apps you can use if you're using a PDA or mobile device, which most of us probably are. So if you're in a solo practice or small practice, I think one of the first things that really impacts what your technology needs is your actual space. Looking at where you're going to actually practice. If you're going to work, or you're working from home, you're starting out like I did. I started from a home office. Then I went to a shared office space, and now when we merged our firm, when we started our firm, we now have a building. So my technology needs change with each progression of my practice. Or you may decide a virtual office or a combination of all of that. So that will determine and sometimes limit what kind of technology you need, what technology you have access to, and how you use it. So once you've done that initial assessment look at what you've got. When I first started my practice, I didn't go out and buy all new equipment. I used the same computer I'd have been using at home anyway, and used the same cell phone I had, and grew as the practice grew. So do an assessment of where you're going to practice, what type of practice it will be, and then looking at what resources you have now, because most of you probably, if you're just starting out and you didn't have the cash outlay to go out and to build an office, you probably have everything you needed to start a practice anyway. And so those simple things, first will be hardware, then we'll talk about software, and again, ask questions as we move forward. So hardware, pretty simple. If you've got a PC, you probably got enough to start. This depends on what kind of practice you have, and what other policies and procedures you have as far as your data backup and your management as well. Most things now, for an example, you can find things pretty inexpensively. A site I go to and get a lot of my technology from, if I can do it in advance, is Newegg, Newegg.com, Newegg.com. You can get a lot of things from your home, for your office, everything you need technology-wise there. They sell refurbished items, brand new items, surplus items, you name it, they'll have it there. So in our office, we just bought a few PCs that were refurbished, former business leases. They were 120 gigabytes, dual core processors, 2 gigabytes of RAM for $150 a piece. With the mouse and keyboard. Came in the package. So granted, were they reused? Yeah, but they were refurbished. Same warranty, 1-year warranty you would get if you would go to Best Buy. But we got them for $150 as opposed to going to buying a computer like that brand new anywhere from $400 on up. So you can still buy good equipment that will serve your needs and it'll be just fine. And those computers were great upgrades for our office and were faster than what we were already using in some cases, but it was perfectly fine. So get something that you can grow into. I don't like getting anything, especially nowadays, if you're looking at hard drive space, nothing less than 100 gigabytes. Now, with everything being digital, even though we still use paper a lot, I convert everything to digital at some point. And when you do that, when you're scanning, going from a Word file that you created in Microsoft Word, and you scan it or save as a PDF, it increases the file size sometimes, especially depending on what you've got embedded in that document. So if you've got some graphics, some photos, all my demand packages now I do for my PI cases, I rarely fax or mail a demand package these days. They're all done via email. I either email them as an attachment or Huey talk about things about some of the cloud technology we use. I use LogMeIn for most of mine, where I can host files on my computer. So it's private. It's not in a public cloud. It's on my network. I send you a link. The adjuster downloads it straight from my system, and they only have access to that one file. And I do that for larger files. If it's going to be 1 megabyte or larger, I use that as my system.
I have a question, Anthony. Do those
Yes,
files
Dolores.
expire? Do those links expire?
Yes, I set, and you control when they expire. I can have it open in it if I wanted to. They can, download it, and I can not only do the expire, but I can limit how many times they're downloaded as well.
But you don't want your demand to expire. You want that to be
No,
open. You can take this
the
anytime
file
you want.
expires, not the demand.
You just have to be clear.
Not the demand, not the demand. So yeah, so when I send that, you assign permissions when you create the link in the first place. So, but because of that, and I think I kind of jumped ahead and went to a software application, but because of that, you want as much hard drive space as you can get. Nowadays, again, you can go to newegg.com right now and you can buy a 1 terabyte internal hard drive for $80. And a terabyte, for those of y'all know, is 1,000 gigabytes.
I was just about to ask you.
Terabyte is 1,000 gigabytes. So, and most of you are not using 1,000 gigabytes right now. You're probably barely using 200 gigabytes, if that. Probably a lot less than that, unless you have a lot of music and videos, and that's what normally, for most of you, your iTunes account is what really drives your hard drive up. The stuff we do as lawyers, for the most part, does not. It does not. Which, to that point, I have a separate hard drive for my music and videos, because I know it's completely separate. So I manage my technology that way. So if you got all those things on a hard for your computer, and again, it's just going to be depending on your space. If you are in an environment where you can have some control over what I call the server closet or the technology closet, or that room, whatever it is, have your computer in a backup system or battery backup. I think APC is the normal thing most people use. It's an uninterruptible power supply. So if there is a power surge in the building or the building power goes out, you've got this basically charging that's been backed up for a while. If you have an alarm system in your home, you have something like that similar to it. If you're familiar, if your power's ever gone out and the ADT guy said you've got another 8 hours before your alarm system goes off, you have an uninterruptible power supply for your alarm system. You can get something similar for your PC as well. So in case there is a power outage, or if it happened to me, you're working on a document and there's a power surge or power goes out, you don't lose what you're working on. And so that's the benefit of that. Now, depending on, again, the type of work you do, if you're doing any kind of criminal work whatsoever, and you're getting discovery, it's going to be audio of a statement or a video camera surveillance. You're probably going to get something on DVD, or depending on the jurisdiction or which agency you're getting it from, they have different software packages for it, but you're going to need a DVD drive in your computer as well to back that up. As a result, I always give my client, I make digital copies of everything. So again, I make a copy of the DVD, give the client, when I close their file out, they get a copy of all their discovery and everything else they have as well. So they have their own video surveillance disc. If I get something from my client that I send somewhere else, I burn it as well. So I also recommend getting a DVD burner. When we talk about software packages, there are different things you can get to help you do that. It's not illegal to copy DVDs if you do it with the right permissions and you know what you're doing. Okay. All right. Any questions about hardware? backup systems.
I think we kind of move on. a little
Move
bit.
on, I am. That's
I think
moving on.
How are we doing on time? I think it's.
We're good. We're good. All right. So, document management. I convert everything as much as I can to a digital format. Not only for. Again, it's going to be limited on your space. So if you're working from home on a rental space or a virtual office, if you can eliminate as much paper as possible, that's the best thing for you. Even if you're in an office environment, like right now we're in a brownstone in downtown Baltimore in our firm. We've got 4 floors and almost no storage space because we got bodies in each of the offices now, which is a good sign, but it means we don't have space for a full library now, which we made a decision, who needs a library these days? Everything is digital. So we don't have a library. We'd rather have conference room space. So where we would have a library, we've got conference room space. Where we have some storage spaces, but right now we call them the dungeons. You wouldn't want to be in that office anyway. And we are in the process now of scanning all of our old client files and converting them to digital backups. So now even in our fee agreement, it tells you our client management is our property management when it comes to your file is that when your case is done, it's immediately scanned, shredded, and saved on our server. And then, as Q we talk about, we go up to the cloud as well. So our backup strategy is, at least my backup strategy, I'm trying to convince my partners to do the same thing, is at least 3 ways. It's on my computer, it's on my local server as a backup, and then it goes up to the cloud. So that's how I back up. And so that's why for us, the hard drive space was critical, because now I went from me and my part-time, every once in a while associate or clerk, to 4 lawyers, 2 associates and staff. We've got to have the space to make sure we can house all those documents as we scan and shred all those documents. We've got to have a space to put them and make sure they're backed up as well. Okay, you look about to ask a question. Nope, moving on.
Question.
All right.
Yeah, keep it rolling.
Telephones, big debate, hardline versus VoIP. Everybody know what we mean by VoIP? Voice over IP. Okay, what that means is you can have a phone. If you're going to be a virtual office, you can have a phone line that you can sometimes physically take that phone with you, plug it into any power source, and you've got a phone. So if someone wants to call you and they do want to call you at 2 o'clock in the morning, they can call your office line and not your cell number.
Well, don't just give those people the cell. The people at 2 o'clock in the morning.
I don't give that. That's a whole separate conversation. But I think part of it is to begin managing client expectations, how you manage your clients as well. Your phone system can help do that for you as well. So I don't necessarily give my cell phone out, but my clients still have access to me. Because with VoIP systems, you can have what's called a follow me service. Someone calls your office, you're not in your office, they'll get the option to say, would you like for me to find Mr. Butler? And it'll call my cell phone and then tell me who it is, and then I can accept or reject their phone call. So you can do things like that with your phone system as well. So that way you don't have to necessarily give out your cell phone number if you don't sophisticated enough or at that point in your practice where you have a office cell and then your personal cell, which most people don't do, but some do.
You can also get a Google number.
I was going there.
Right.
Yes, you can get a Google Voice number that allows you to go straight to your cell phone, and know it's somebody calling from the Google Voice number when they call your cell. Everybody know what Google Voice is? So Google, one of their many business applications they have, allows you to basically create a vanity number, so to speak. Not like our vanity number is 685 legal. Legal being the vanity part. Yeah, didn't know that, did you? 685 legal. 410-685 legal. But it's on your pins. But
shameless parking.
But it allows you to create a number that you can pick your area code, you can pick your market. So if I wanted to open a market back home in St. Louis and open an office there, but wanted them to call me here, I can create a 314 number that I can give to my St. Louis clients who would call that 314 number, but it will ring at my Baltimore office. So Google Voice would allow you to do that by creating a number in those jurisdictions or counties even, if you wanted to do that to create a presence. Because some people still don't like calling area codes they don't know. They want a local touch. So you can do that as well.
And it's free.
And it's free. That's the best part about it. It is free.
At least free for Sprint customers.
Yes, ma'am.
I have a question about the Google Voice numbers.
Mhm.
I actually have been using that for I think the past year. And I noticed that yes, you can choose a different area code, but if you try, let's say you missed a phone call
Mhm.
and you try to call it back.
Oh no.
You can't do that
No.
because your real cell phone number
Exactly.
will come up.
However,
so how do you get around that?
there is another app There is an app you can download, or there are a few apps you can download where you can disguise your number that calls out. So I forgot to, because I stopped using it after I got into our building. I stopped using it. I just have my assistant call, and she just bridges the number. So I stopped doing that. But there are apps you can find where you basically, before you dial the number, you go to the app first. You put in the number you want to dial, and then you put in the number you want to appear on their caller ID.
This seems to be too involved. Just gonna call him back.
It sounds very stalkerish. Okay. It sounds very stalkerish, and ironically, that's how I found out about it, was from my family law clients, because that's what they were. That's what somebody's ex was doing. He would put in her mom's number and call her. That's terrible. And she would think it would be.
That's not terrible. That's a creative way to get to what you want.
So in this situation, I actually use client information I got from a client.
I hire that guy. I like that.
Yeah, I gotta ignore Huey sometimes. But no, so that's how I learned about those types of programs. But it's spoof. That's what it's called, spoofing. You can spoof your number, is what it's called. So yeah, you did hear about that. Because in those programs also, this is the stalkerish part. Really, they also let you disguise your voice too. I don't advise you.
No, wait a minute.
I don't advise you to use that. Right. I'm just saying. So most programs give you that option. You can put in the number you want to dial, put in the number you want to appear on the caller ID, and then you can call it back. But for some, it can be a lot of work, because you can't just dial straight from your phone. You've got to you don't do it while you're driving. You have to really be somewhere you can set up the time to do it and call it back. The last thing on hardware is your data connection. You've got a good wireless router or router that can service whatever space you're in. So I had to upgrade from my little 4-port router to the building we're in now, where we have a 16-point router, so we can feed hardline internet service and network service to all the offices in our building. But if you've only got a home network set up, you can probably get a 4-port router or wireless router that you're probably going to get from Verizon or Comcast, or I forgot the VoIP. What's the one big service that does VoIP? I forgot.
Ring Central.
So they all are now providing you devices as well. The other last hardware piece, MiFi Wi-Fi. This is my MiFi device. This is my mobile internet. So what it allows you to get Wi-Fi service. I personally prefer Clear over Cricket. It's 4G service. $50 a month, no contract. You buy the unit, it's yours. So no matter where I go, I can get it. Yes, ma'am.
Can I ask, this is kind of embarrassing, but I'm about to dump my BlackBerry for something else.
Thank you, Jesus.
And I'm wondering, in terms of like work email, if you have any recommendations for what kind of phone to buy, or it doesn't really matter. I know for BlackBerry, they're kind of separate.
Yes, they are. And I am a former BlackBerry addict myself. I still miss the email application of BlackBerry, because it was instant. It was push-pull, where most things are pull, which means you have to tell it. Like I think on Android devices, it only will sync every 5 minutes. I think you're used to on a BlackBerry that it constantly syncs.
No, it'll sync as much as you want to sync.
Well, my phone only
15 seconds.
Mine only syncs every 5.
You might need an upgrade.
Which I do, but I think I still think that's a delay. That's the thing that BlackBerry had over most systems, was that their email exchange was faster. It's almost real time, as opposed to most of the phones we're on now. So that's another good debate about hardware, is which type of mobile device we use. When Huey talked about his apps, some of them are mobile apps. Right now, most people are either on a Droid's phone or on an iPhone. I still have a preference for a keyboard, so that's why I will probably never go to iPhone, because I like having a keyboard. But each device has benefits and advantages. But to me, as long as you've got a good connection and you've got some onboard storage of at least 16 gigabytes, which I think most phones have nowadays, that'll help you out as well. Because now I use my phone, instead of using a thumb drive to walk around with, I use my phone almost as a portable hard drive that I use. I can just plug into any computer if I want with my SIM card, and I can show client videos. If I'm in court, I need to show opposing counsel something I think is a strength of my case and a weakness in theirs. Like, check this out, show them on my phone, and sometimes you'll be amazed at how actual video will change the outcome of your case. So, but you can do the same thing with iPads. any Droid tablet device, any laptop computer, just have, I guess now as I segue the software, have something that will be able to play videos and that can do it in a clear way. Word processing, when it comes to software, I am still Microsoft Office is what I use for the most part. 2010, when if I look at the things I use often and constantly on my PC is Outlook. We have not gone to a client management software application yet. We still use Outlook for calendaring, for reminders, for contact management. We're probably what we call power users of Outlook because of that, because that's all we use every day, all day. So we use Outlook and we for our syncing everything. Timing and billing, you definitely want to do something with that. As we prior to the session starting today, one of the conversations we had was, whatever you do, make sure you get paid. So invoice often, invoice frequently. You don't want to work for free. You can do that for someone else. Don't do it for yourself. So QuickBooks, Goldmine, Time Slips, Time Matters. There are all kinds of software applications out there for you to use for your billing and your accounting. If you do want law practice management software, there's Abacus Law, PC Law, STE Practice Manager, Time Matters as well. You use something different, or do we name it? Needles. Okay. Yep. And if you, depending on which practice areas you use, there will be some other applications you want. So I know a lot of people in family law to calculate child support guidelines, they use Salsi Calc. I just learned of a free but limited bankruptcy software package called Fresh Start instead of the big right. That's what. Hey,
no pun intended.
Hey, I didn't write it. For email, one of my biggest pet peeves when I meet lawyers who start out who are still using Gmail, AOL, Hotmail accounts for your firm and for your business. Don't do it. To buy a domain name, everybody know what a domain name is? Mm-hmm. All right, so a domain name can cost you $10 a year.
But you still can have it hosted by Gmail.
And you still can have it hosted by Gmail, but get a domain name. Your name, .com. I don't care. Get something so that's part of your marketing, your advertising as well. So once you do that, that becomes your email address. So it's Anthony, mine is abutler@tbmglaw.com. Before, when I was in solo practice, it was Anthony@abutlerlaw.com. So always have a domain name and then have that sync to your Outlook, your Gmail, and they can go to your phone as well. So just make sure you have something that can do that and can maintain it. Yes, ma'am.
Okay, so you say you discourage Hotmail.
I discourage Hotmail accounts because it's a lost opportunity for you to market your business. Okay. That's the only reason why.
Not that Hotmail is bad. Who hasn't had a Hotmail account?
Now there is there's this other security issue why I don't like. One of the debates we've had in our firm is going to Google Calendar for our calendar, and I just refuse to do it because Google has had too many security issues, and I store certain data in my calendar appointments that I don't want the public to have access to.
You think somebody's gonna steal your calendar?
Hey, possibly.
I'm giving you a hard time.
But
this is what we've become.
Yes. So some things I don't do. So because of security reasons, I think ethical reasons as well. Because even if you are, for example, if you are running a virtual practice and you're using your cell phone a lot, I don't discuss substantive work with clients on cell phones because they're not secure. So if it's a settlement offer, if I'm talking to about the intricacies of their case, hey, we'll talk. What is the issue? Okay, fine. I'll call you back from the office. I'd rather call you from a landline than I call you from a cell phone because it's still, to me, they're not secure. And on top of that, again with email, it's if you're using if somebody else is hosting your email, again, you don't really control who's hosting it and how you can get access to, or who else can get access to that data. So same thing along those lines. Email is firm websites, easy to host and create your own website at GoDaddy, 1in1.com, Google. All have simple packages for you to put up, even if it's something that says this is who I am, nice professional picture, name, phone number, address, brief description of what practice areas you do. That's better than having nothing. Because most times nowadays, these when clients come to me, and by the time they come to their first appointment or their consultation, they've already looked me up online. They already know what we do. They already know how many people are in my firm. They already know because my bio's up, everything else. So they know what our experience is before they come to us. I found it happens more often than not these days. I think I ran through that.
Yeah, I'm about to.
One last thing I didn't do on it's not on your handout is we talked about it with someone else earlier, is credit card processing. Definitely sign up for credit card processing, but don't buy a merchant terminal. Use either Square. Everybody familiar with Square Up? Site called SquareUp.com. Small nominal fee. It send you a little small insert that goes into, you can use it on your phone. It plugs into the earphone jack of your phone. It actually will swipe a credit card. They charge you per transaction as opposed to charging you a monthly fee, which is what a merchant terminal would do. They're going to charge you a monthly fee and still charge you a percentage of whatever transactions you do. Square does not. We've got two set up. We use one through our QuickBooks, which only goes into the our retainer trust account, and we use Square for our flat fee work that goes into our operating account. So that's how we separate the two. We know which one is to be used for which, and that way we can manage the fees, because I'm sure Dolores will tell you that when you swipe a credit card for a retainer account or the retainer amount, and they take that fee out, well, guess who has to replace that fee if you don't charge it back to the client? You do. So you can do one of two things: call your credit card merchant account, your merchant vendor, and ask them to take the fee out of your operating account, or charge it back to your clients.
Which produces another problem. Then you actually have too much money in your trust account, and that's also a violation.
That's also a violation, exactly. So you have to talk to us offline. You and I have dealt with it before. Too much to go into right now, but the point is, be careful that if you're going to charge, if you're using your credit card to accept fees that are trust account fees, that you have to account for that merchant fee as well, because that's still the client's money. Just because you offer it as a service, we got to make sure that that is still, they still have the full access to all the money they put into their trust account.
And because that amount can change every month, if you do have it associated with your IOLTA, your escrow account, you have to actually try to sit and manage and calculate how much it is that you should have in your escrow account
monthly.
Because
you should be doing that anyway, though.
What Bar Council is saying is
my goal is to bill out every dollar you give me by the end of the month, every single month.
That's nice. What Bar Council has seen is that attorneys are having overdrafts on their escrow account, and when those overdrafts hit, Bar Council by statute has to be notified. And a lot of times attorneys are saying they just got a new vendor, a new merchant terminal, and the merchant has messed up how it is that the fees are taken out. So really the onus is up to the lawyer, and the obligation is on the lawyer to make sure that they have squared away where those fees should be taken out and apportioned. Go ahead.
Yeah. Regine, was that a question or you a
Oh, no, I was checking the time. Can you charge the fee to the client?
Yeah.
I think you discussed that last time.
We did. But yeah, you can definitely charge. And I've had clients, we just instituted that as a policy at our firm, and I've had clients say, never mind, and come right back with a cash payment. But hey, it works for me. So it's their choice, it's their option to do so.
Cash is always appreciated.
Cash is always appreciated. So and that just depends on whatever your policies are. I know. So yes, sir.
I just wanted to add, because I like techie stuff too. There's a program I found that's free called Rescue Time that has been amazing for me, because it's an app that goes on your computer, and there's an app for your phone, and it does all the tracking every day for you. So like if you call a client, it has their name, you just go into your sign-in, and it tells you were on the phone with the client A for 3 minutes. And same thing on your programs, it tells you what you opened, what website you were at, so you don't have to worry about your billing or what you did.
And it syncs between the two?
It syncs between the two.
What's it called again?
Rescue Time.
Learn something new every day.
I've heard of that app.
Question. I'm at a firm, but I was just curious.
We're going to move through this. We're going to have, because we only got about 10 minutes left. So we're going to move through the cloud-based apps. And then we're going to go through questions. I'm going to give you 5 minutes about Clio and a few things, and then we're going to move on. And you can ask any question you want. All right. Again, my name is Huey Hunt. I'm the moderator here. I've given this presentation over the summer, and actually I was talking to the cameraman. He's been following me like all year, because I think he's videotaped every presentation I've given. I'm just going to talk to you briefly about Clio. There's a world of apps that I've listed, in my packet. We only have a limited amount of time, so I want to talk to you about what Clio has kind of done for my practice and, how it's helped me. Many of you are solo or small firm practitioners. I started where you were. I was on my own, and it's hard to believe how the world has changed, because when I started in 2001, no one had a website. Not one person, no big firm, no one had websites.
I was one of the first small firm, solo firm people to say, let's get a website. And then now, fast forward 10 years, 11 years later, if you don't have a website, no one even takes you seriously. So the world really has changed. And all the practice management applications that Mr. Butler mentioned, I've tried them. Time slips, Time Matters, Abacus, PC Law, Amicus, you name it, I've done it. And what I've turned to in my practice is Clio. It's a cloud-based system, and I'll tell you a little bit about it. Some of the other systems, first of all, you have to have somebody download it for you or install it in your office, and that's a day or two process. And then there's always ongoing kind of technical issues. With Clio, it's cheap, it's easy, it's $30 a month. You have your calendaring, you have your billing, you have everything you need to practice law, and it's a totally kind of a internet environment. It's never down. It's a login. You can have multiple players on it, and it speaks within itself. So when you put your time in, all you have to do is click another button and produce a bill, and bam. When I started, I don't know if any of you, if you're trying to do bills, the legal work was the greatest thing. The worst thing I ever had to do was go back to the office and do a bill. I hated it. It was like a nightmare. I procrastinized. I looked at the screen. I got up, got some water, walked down the hall. You know, it took hours, right? That was me. I don't know if that's you. But think about this. If you use your phone every day, right? Would you pay your phone bill if they never sent you a bill? No. But lawyers somehow think clients will magically pay them if you don't send them a bill. You have to send people bills constantly. And this is my number one hot tip. Sending someone a bill will get you out of bar counsel's way. Why? Because they'll know how much it costs. They'll stop calling you, right? And if they continue to call you, then they know you were billing them. Then what are they going to say? Nothing. Billing is almost the most important part of your practice. And it's usually the part that we all kind of push to the side. But the administrative part of your practice, and Dolores can tell you, can get you in trouble. Writing letters, very important. Very important. Communicating, very important. Actually, the most important thing is communication. Because you're the lawyer. You have 50 cases. Your client has one. And when they go home, they think about it. They dream about it. Right? When you go home, you're like, why did I go to law school? What am I doing? So you're always fighting that dynamic. And this summer, and the cameraman knows, before I left for vacation, I gave this presentation on Clio about how I could practice law from Panama, which is where I went for, I guess, July. But I was there. I had Skype, right? I had Clio.
I'm sorry, you went to Panama for July?
Yeah, I had to come back.
Everybody caught that, right? He went to Panama for July. All right.
So I had Skype and I had Clio. So I was literally on the phone with my office every day, and she was sending me messages just like I was down the hall. And the Skype number cost me like $15. It's really simple to practice anywhere you want. So the number one thing I would tell you as a small firm, somebody starting out, is get you something like this. Not necessarily clear as other things, Rocket Matters, but this has been something that's worked for me, and I'd be happy to talk to you all, after the session to kind of enlighten you on some other points of it. Google, an amazing resource, free. Google Scholar. I mean, you can type anything in there, and it'll bring up cases, things you probably didn't even consider. It's totally free. Google Voice, I use that. Google Translator. Has anyone used that? It's actually an amazing. You look to the last page. I don't know if Dolores cut that out. You cut it out, Dolores?
I didn't cut anything.
I don't see it in here.
Not slide 6, page 6.
Google Translator. So cash is appreciated as a retainer. You can translate that into Haitian Creole. Are you kidding me? This is amazing. I mean, that's just amazing. Profiles, you can do a profile for yourself. I mean, if you Googled yourself, you should do that. These are all things for you to kind of, create ways to get more clients. We talk about hot tips. One hot tip I have for you is to read, if I had to tell you to read one book, I'd tell you to read The 4-Hour Work Week, right? And it's not necessarily designed for lawyers, but so many of us think, you know, the way we practice is we get a retainer and then we just bill some hours and then they send the money. The world has changed. We now live in a society where you want things to be efficient. You don't necessarily want to be there all day. You want to be more productive when you're there. So all these tools we have should lead you to be more productive, where you can try cases, more cases than you could try last year, or try them better. So that's one hot tip. Second hot tip, if you don't like your client in the first meeting, walk away. If you don't like them, it's going to be, that's a sign from God. It never gets any better. After the first meeting, it never gets better. If you don't like each other in the first meeting, the odds that you'll like each other after 18 months is very low. I could be wrong. I'm just going on my own, run-ins with clients, okay? Because at the end of the day, you're the lawyer. And everyone blames the lawyer. They never blame themselves. They never blame the facts. They never blame the evidence. They don't even blame the judge. They always blame the lawyer. You have to understand that. And you have to live in it. But you need to be proactive in the way you approach the practice of law. Because you worked a long, hard time to get it. And every opportunity to have a client is an opportunity to lose your license.
Nice, Huey. Now we're going to segue into ethics.
And I don't mean to scare you, but the truth is the only person that can ever hurt a lawyer really is their client. If you look through bar counsel's complaints and people who've been disciplined, people who have lost their license, 9 times out of 10 is at the hands of a client. That's just the truth. Some of these folks you come in contact with will love you to death because of the great work you've done. Others won't like you so much. And you may get a blue letter. But you have to protect yourself from that. And these tools can help you increase your communication. So take a look at the packet. I'm going to open it up for questions right now.
Huey, I'm going to do a little thing on ethics, just briefly.
Okay.
I did a handout that's called Ethical Boundaries When Negotiating Settlements. And in it, I listed a number of rules that you should consider when you're entering into negotiating settlements, or if you're entering into mediation or arbitration on behalf of your client. And the number one thing, of course, as an advocate for your client, is that as an advocate, you're going to have competing interests, okay? And that is, one, you want to be sure that you represent your client zealously and competently, but you also have other interests, other people, and that includes opposing counsel, third parties, and some of these third parties, were mentioned a little bit earlier. They might be insurance adjusters, they might be medical providers, they might be, persons that, have some sort of interest in the outcome of your client's matter, and in which case, and I cited them, and I won't go through each one, but of course, Rule 1.1 deals with competency. 4.1 is truthfulness. As a lawyer, what we are charged to do is to be scrupulously honest. Okay, that's the heart of what a lawyer's job is. So 4.1 is the rule.
What if the opposing counsel asks you if your client is lying? Should you tell the truth or should you protect your client?
Well, Huey, that all depends. I mean, come on. If your client has lied, I mean, you have a duty to your client, of course, to keep the client's confidences and secrets a secret. But if there is information that your client, has put out there that is false or is untrue, as a lawyer, you can't co-sign on what your client has done. And I listed some cases.
But can you tell them? Can you say my client is lying?
No, you can't do that, Huey. Under Rule 1.6, you have to keep your client's information confidential. But of course, if you act in such a way, you can't make a material misrepresentation on behalf of a client. You can't, and there's a case that came out of Maryland, Attorney Grievance Commission versus Rohrback, and that was a case where, a client He was arrested for DUI, and he gave the arresting officer a fictitious name. He had a false, phony driver's license. So he told his lawyer that he had his false driver's license, and throughout the proceeding, he was going by this false name, okay? But there were different parts of the case, and then he had a second charge where he had under his real name. So there were different parts of the case. Now, the lawyer didn't necessarily appear at court on his behalf. The client did that himself. But there was a point where the lawyer accompanied the client to the probation officer. And although the lawyer sat there and didn't say a word, essentially, because of the act of him showing up with his client, it was as if he was co-signing that the client was who he said he was. And for that, Mr. Rohrbach was found to have violated Rule 4.1, which is lying by omission. So, essentially, if a client, asserts a fact that is not true, and the lawyer doesn't necessarily do anything to stop the client or, get the client to remonstrate that, the lawyer in that instance will be found to have also assisted a client in committing a fraud, which is 1.2. You have a question?
What you said just triggered something. What if someone asked you to stand in for them and their client is on the slippery slope of doing whatever? By extension, if you standing in for somebody, you wouldn't know. Someone say, typical case like divorce, and they're siphoning money off to wherever they're siphoning off for, and you stand in for them at, say, a scheduling hearing or something like that.
Well, here's the thing: the Article 3 rules pertain to candor towards the tribunal, so those rules are different, okay? Now, as an officer of the court, your ultimate duty, of course, is to the court. So you cannot, of course, assist the client, even if you're standing in. So if you know that a client is about to, commit perjury or give false evidence, you can't assist in that regard in any way. And if it has occurred, of course, as an officer of the court, you have a duty to correct the record, even if that means you have to, tell on your client and say, hey, Your Honor, so-and-so lied. But that rule is a little different, only because, as an officer of the court, that will trump your duty, of course, to your client. But under the Article 4 rules, those deal, and that's why we're talking about them now with negotiation techniques, because in those settings, they deal with third parties, agents of opposing parties, perhaps opposing counsel. Those are different situations where you're not, before a court, no one's under oath. So that's a little different, but that was a good question. I am going to fast forward through Rule 4.2, of course, is communications with represented parties. As you all know, you are prohibited from having communications with a person that you know is represented by counsel. Okay, even if, and there has been an ABA opinion that has come out recently, even if that opposing party initiates conversation or communication with you, you still are prohibited. The only thing you can say is, you're represented by counsel, you need to talk to your lawyer. I can't talk to you. Okay? So that's Rule 4.2. Yes?
If someone's looking for new counsel, what process or advice should you give them for how to handle if they're looking for a different lawyer, but they're coming to you for advice?
Well, they're represented, so, you can't talk to them about the substance of the representation. At most, you can say to them if they're unhappy, they should perhaps terminate that representation, and then, you might be willing to talk to them after that, but, you shouldn't engage in communication with someone who is represented. Yes?
I got an email from the client from opposing counsel. I guess she sent it to me in error. So, because I guess the other attorney had forwarded a message that I had sent to the client. So the client sent me a message. I didn't respond to the client, but right. I contacted the lawyer and said, the other opposing counsel, and said, your client sent me this in error.
Yep, that's the appropriate thing to do. So even if like I said, the contact is initiated by the opposing party, you can just direct those communications straight to the counsel, just to put them on notice that, this inadvertent error, I assume it might have been, was made. That way, and the rules were created really to prevent lawyers from overreaching. So you want to make sure that you're never in a position where an opposing counsel or someone will say, you did something that's improper, or you engaged in some sort of misconduct by reaching out to these persons. Another important aspect, and I'm just going to kind of skip through this outline, another important aspect of negotiations is dealing with money. If you are in a situation where you have successfully settled your client's matter and a dispute arises, okay, either between you and your client or your client and a third party, Rule 1.15E will dictate what it is that you can do. And essentially, what Rule 1.15E says, as a fiduciary, you have a responsibility to not only your client, but whatever other third interested party that there is, okay? So if there is a dispute, the lawyer has to hold those disputed funds in trust until the dispute is resolved. And we see this situation a lot. It comes up a lot in personal injury cases in particular. And a common example is if a client or a lawyer or a client and a lawyer sign what's called an assignment and authorization agreement. Essentially, that's just a contractual lien between the medical provider and the client and the lawyer. Even if the lawyer doesn't sign, but if the lawyer is aware of it, it still binds the client. It's still a binding contract. And there have been situations where after the matter has resolved, the client will say, "Well, I didn't like Dr. So-and-so's bedside manner, so I don't want to pay them that. I will be responsible for the debt myself. I want you to release to me, the net sum of my settlement." And we see a number of cases where lawyers are doing just that. They say to the client, "Okay, well, you understand you're responsible. Here's your money." And next thing you know, the doctor files a complaint with Bar Counsel saying they didn't honor my lien. Essentially, under Rule 1.15E, that third-party medical provider almost stands in the place of a client. So as a fiduciary, the lawyer has a responsibility not just to the client, but to that third interested party.
Even if they don't sign?
Even if they don't sign. If the lawyer is aware that the client signed, the lawyer's on the hook.
But would that extend to other situations where
No,
a
if
client
Macy's-
has other creditors?
No,
with
if
the
Macy's
sign-
came calling and said, "Listen, Mr. Smith owes us $500 for this outstanding bill." As a lawyer, you don't have an obligation to pay Macy's, one of your client's creditors. It has to be an interested third party. So essentially, in the example that I just gave, the lawyer and the client, what they did was they entered into a contractual lien whereby they used the case kind of like collateral, if you will, to ensure payment at the end. So that would be like,
So it's not limited to medical providers. It could be an investigator in the case, or
if there is some sort of contractual lien, if that person can make an argument that they are an interested third party. Another example would be if that person has some sort of statutory right or claim to the monies. I mean, we see, probate cases where, lawyers turn over monies to people that they shouldn't, family members who, come out of nowhere. But if there isn't some sort of statutory obligation to do so, then, of course, the lawyer shouldn't engage in that. Another thing you want to be mindful of is if you commit malpractice, and if you're attempting to negotiate a settlement with your client, because this happens. I mean, lawyers are human.
no, we're not, Dolores.
No,
Don't
lawyers
say
are
that.
human, and mistakes happen. But if you make a mistake, of course, the best thing to do is to immediately let your client know that you either, you may have committed some sort of malpractice.
Do you really say that to him? Oh, hey, Jane, yesterday I committed malpractice, but
Well, I mean, listen.
want to have dinner later or something?
If there's an issue, there is really no reason to hide behind it. And what I find working at Bar Counsel is that clients appreciate lawyers that are straightforward with them. Okay, and really the happiest clients are the ones that communicate with their lawyers. Okay, so if your clients like you and communicate with you, even if you mess up or tell them bad news, they generally won't complain on you. They really won't. So if you do commit some sort of malpractice and you want to negotiate some sort of settlement with your client, of course, under Rule 1.8, the thing you tell your client is that they need to, in writing, seek independent review, independent legal counsel, okay? You should not ever attempt to negotiate a settlement with your client on your own. They need to go ahead and get their own lawyer, and then you also have to give them an opportunity to actually have that other lawyer review the matter. So if you tell them, I'm willing to settle your matter for $10,000, this offer expires midnight Friday, you know, that could be a violation of Rule 1.8 because you're not really giving them an opportunity to go out, seek other counsel, and have that counsel review. So that's something you want to be mindful of. And I know we're running out of time. Retainer agreements, I'm going to just talk about briefly. You know, it's not required, it's Rule 1.5B. It's not required to be in writing in Maryland. I always recommend that you should have it in writing. Contingency fee agreements are required to be in writing, but you should always have retainer agreements in writing. There's no such thing as a non-refundable retainer. We are getting more and more complaints where, you know, attorneys are providing copies of their files and, you know, clients are providing us copies of these retainer agreements where they have this language. And there's no such animal. Okay, so if you have it in your retainer agreement, it really needs to come out. Bar Council has, you know, Bar Council in Maryland, it's their position for years and years that no such animal exists. If you're doing flat fee work, I know historically practitioners have always put flat fees into their operating account and considered it earned upon receipt.
Cash and carry is what they call it in the trade.
Listen, that is improper, okay? That's improper.
You're going to have to shut down the district court system.
Listen, it's improper. Unless.
Nobody going to have no lawyer over there.
Unless.
Saving grace.
No. I mean, if you want your client to waive entrustment, Rule 1.15 dictates you have to get your client's informed consent. And essentially what that means is you have to have that conversation with your client where you discuss with them the risks and consequences of essentially taking their money and treating it as your own. So you have to let your client know that their money that will now sit in your personal account or operating account will be subject to your creditors, okay? And your clients have to understand that. And you need to put that in writing. Okay, so if you want to waive entrustment, and I don't know how many people want to have that conversation with their client because it's a little uncomfortable because what the client will hear is creditors. You have creditors? What's going on? You know,
it really doesn't sound good.
It doesn't sound good at all. But, you know, there is a way to waive entrustment, and that's the only way that you can do it.
So if you're using flat fees now and you're not doing it, you fix it. One thing that I will recommend is that it's in bold in your fee agreement. There's a line next to it that they initial in addition to signing the fee agreement, and that you actually do have the conversation with them. You can't just say, oh, well, they signed the fee agreement and they initial by the clause. That's not good enough. You got to actually have the conversation and then take those extra steps so it sticks out in your fee agreement. This big old bolded section that says, this is my money. Once you give it to me, initial here, I've explained it to you, sign the agreement, and those are steps will help aid in your defense if need be.
If need be.
If need be.
And lastly, sorry, you have a question.
Yeah, what happens if later you have some sort of agreement, retainer, contingent, whatever, and the client later disputes saying, I didn't understand that's what you meant, blah, blah, blah. I mean, what's the best way to deal with something like that?
How much money is involved is the first question. Because if it ain't enough money, just let it go. Move on.
Well, listen, if
that's just the truth. If it's a significant amount of money, then you may want to go to the mat on it. But it can cost you so much in time and defense, and the person who feels like you wronged them will go to the ends of the earth to make your life miserable. And you have to do a cost-benefit analysis. So no one can tell you exactly what to do. But
yeah, if it's a fee dispute, I mean, Bar Council won't decide fee disputes. If it's just a fee dispute that doesn't raise any other red flags such as unreasonable fee or anything like that, Bar Council will usually dismiss those kinds of complaints and send them off to, you know, whatever Bar Association Voluntary Fee Dispute Committee. But, you know, you have to, you know, make sure you want to go through that process. So, you know, if it's worth it to you to compensate your client, or come to some sort of understanding or, mediate or resolve the matter, it might be worth it to, avoid these kinds of grievances.
I always ask people what they want. What do you want? Ask them that, and then you can kind of move from that, from that place.
If there's no agreement, then who ultimately settles it?
If there is no agreement, like in writing?
Between the client and the attorney, who ultimately would decide the outcome?
The Bar Association has a fee dispute section, but that may not even qualify. It really depends on what your client is saying. If your client is saying, okay, I signed the agreement, these are the fees, I just didn't know that this was the terms of the agreement, that's one thing. If they're saying, I signed this agreement and, well, you told me something different, then that's another thing. So you have to first assess what your client is actually saying before you can kind of move to a place where it just becomes about money, or is it going to be something that's going to be a little bit more, involved. If it's just about money, you can go right to the Bar Association. They have a fee dispute section. You can submit it to them and they'll resolve it for you.
Last point, escrow accounts. If you are the managing partner of your firm, or if you are, a solo practitioner, you need to appreciate the responsibilities of handling an escrow account, and you need to understand what those rules require. So if you haven't already looked at Rule 1.15 or the Business and Occupations Professions articles, which is Article 600 et al., look at those sections, because you want to make sure that you understand everything that's required with regard to how to properly handle your attorney trust account, even from the titling. So calling your account an IOLTA account is improper and a violation of the rules. And we do see complaints from, Bar Council does get notification from banks, and we find out, based on how an attorney has their account titled, that they've already violated the rules if they've called it, something other than Smith Attorney Trust Account or Client's Escrow Account or something along those lines. If you call it, IOLTA account or some other designation that's not set forth in the rules, and that's a violation.
And have a discussion with your bank, because they don't know that necessarily. So
They don't know.
They will automatically call it an IOLTA account. You have to tell them, please do not name this an IOLTA account. You have to tell them what to name it.
I know many of you are sitting here thinking, I have at least 5 bar violations. Don't tell Dolores about any of them. Talk to me. We'll help you.
And the reason why, I stress, these points in particular that deal with money is because the Court of Appeals has a zero tolerance with regard to mismanaging or mishandling entrusted funds. In every jurisdiction in the country, misappropriation is a disbarable offense. Okay, in DC, Maryland, Virginia, you name it. Commingling, it's worth a suspension, at least 6 months. In the District of Columbia, at least 6 months in Maryland, if not more. Okay, and the Court of Appeals, I'm telling you, they're taking a very hardline approach with regard to how it is that attorneys are handling money. So if you are in charge of, your firm's revenue and your fees, you want to make sure that you're doing it properly. And if you need help, of course, you can contact the Loma office, Pat Yeviks. They have, tons and tons of software. And I don't know if they, actually come in and will do like an assessment of your practice. I know in the District of Columbia, Dan Mills, over Law Practice Management, he will do a sit-down assessment with you and go through your firm's software and figure out if you're doing what it is that you need to do to properly account for those funds.
What's the Loma office?
Law Office Management.
Mm-hmm.
Dolores, can you answer a question I've been trying to fight with the Grievance Commission about 10 years? What exactly is an unreasonable fee? I don't know what that means.
Well, under Rule 1.5B, there are like 8 different factors that Bar Council looks to. There aren't a lot of 1.5 cases.
How can attorney's fees ever be unreasonable?
Well, it depends. I mean, I've seen cases where lawyers are charging $1,000 an hour. Okay.
If somebody's willing to pay it, then I say it's reasonable.
It depends.
You're being
okay?
audio taped and video.
It depends.
At the point in my career when I can charge $1,000 an hour, I won't give a damn about no video
if you
tape.
have the requisite experience and knowledge base, then yes. But if you are a new lawyer charging that much, then no. Any questions on anything I've mentioned?
No one's going to ask you a question, Dolores. No one wants to draw attention to themselves. Trust me, I've sat in that seat and I thought, damn, I just did 3 things wrong yesterday. Don't ask her any questions.
Okay. Well, I think we are done.
Any general questions? Not a peep?
I have a quick question. In the ad, you mentioned insurance. Is there a good, easy place to find different insurers other than
Malpractice insurance?
Yeah, other than kind of here and there. I mean,
It-
is there
it's-
like a list somewhere of helpful?
There's no list, there's a whole gamut of people. I would
Right.
tell you to shop around, because some of the bigger companies, give better rates. And I've had Minnesota Mutual, Legal Mutual, CNA, all of them over the years. But some of the bigger companies have better rates. Zurich comes to mind. Just go on and Google it. There's all kind of people that insure you.
I found this on the American Bar Association's website, under the practice management, and it'll even tell you which states.
Under practice management?
Any other questions? Okay, well, we want to thank you all for taking time out of your busy evening to join us for this interesting discussion. I want to thank our moderator, Huey Hunt. Thank you for leading us. I want to thank Finnegan, Tiffany, Anthony. Thank you so much for sharing your wisdom with us. I want to thank our co-sponsors. I see that Dr. Douglas Sims has walked in. If you can stand up. From Sims Chiropractic, thank you so much for co-sponsoring. Thank you to Meryl Ladd. And thank you, and we have our chair here, Elizabeth Morris. I think she wants to make an announcement about our open meeting, right? What's the date for that?
Our open meeting is November, I'll tell you the date of elections. I think it's November 7th. Yes, it's November 7th from 5 to 8 p.m. It's in Timonium. It is at the Still. The topic this year will be going before OAH.
Administrative hearings, great. And we have handouts on the front table that give more information on that open meeting.
Or if you like us on
Hey,
Facebook,
could you tell them what type of proceedings are in the OAH handles? Just for people who don't know.
well, OAH, there's different types of cases that you can go either before district or circuit court, and they have different types of hearings, MVA hearings, civil rights, human relations hearings. So if you haven't been in front of OAH and you're a small or solo practitioner, you probably will be. So it's definitely something that's really relevant to younger practitioners. So I would really hope and encourage everyone to participate.
Also, isn't the solo small practice group having another one of their things in November, one of their
Yes.
all-day
It's our
there?
conference.
I don't know what day it is, but for those of you that are still interested, I'm guessing there's still spots available.
Right, and I believe that that's November 13th. I don't have that. 16th.
16th, and that's an all-day, for solo and small
And
practice.
just a little plug, I went to that when I started my firm, first
And
year.
it was a good.
12 years. It was about the second one, 11 or 12 years ago.
Yeah, and it's an all-day thing, right?
It's an all-day.
If you don't know Patty Yevix, you'll meet her there.
And it's definitely something that, if you go, we have our website, the Young Warrior section, yls.org. We have an events section of the website, and we include not only the events of the Young Warrior section, but events that are interesting to young warriors, such as we'll include the solo day as well on there. And like us on Facebook.
And follow us on Twitter at Marilyn.
Great.
We're all over the technology.
All over it.
Thank you all.
Thank you.